Welcome. I'm Eric Carlson. I'm a lawyer with the National Senior Citizens Law Center. It's my pleasure to be presenting this material on behalf of the National Academy of Elder Law Attorneys, talking today about nursing home advocacy on behalf of nursing home residents. And the starting point is the federal law, the federal nursing home reform law that applies to every nursing facility certified for Medicare and Medicaid across the country. And it doesn't matter what the reimbursement source of the particular resident is. So whether the resident is under Medicare reimbursement or Medicaid reimbursement or paying out of pocket or covered by some private insurance policy, doesn't make a bit of difference. The nursing home reform law was written to be broadly inclusive and to protect everybody. So part of the federal government's interest is in the judicious use of Medicare and Medicaid money, but the other part of the federal interest is just making sure that people are okay in nursing homes, that the standards are good, and we want to, as a government, as a country, to provide good standards regardless of the reimbursement source for those particular residents. The building block philosophy is a provision that the resident should get the care that's necessary so that he or she can have the highest practicable level of functioning. So, in short, that the residents should get the care that's necessary. And for some residents, it means they'll get the care that's necessary for their condition to improve. For some residents, it means they get the care that's necessary to keep them in a relatively steady state. And for other residents, it means that they'll get the care that's necessary to keep their rate of decline relatively lower than it otherwise would have been. And we're going to be talking about several provisions that are particularly important in the life of a nursing home resident. The first is this idea of care planning. And before we do that, it might just be helpful to take a step back and think about the philosophy of the nursing home reform law. It was passed with this idea that pre-nursing home reform law, the nursing facilities were much too institutional, and there wasn't enough focus on the particular resident. The federal law at the time was much more mechanical, and it had some mechanical measures of adequacy of care, but the missing piece was, what about the residents? What about the people who are there? What about the health care they're getting? And what about their living conditions? How if we expect people to potentially be in nursing facilities for days, weeks, months, years, we should do something to protect their quality of life. And so the reform law is written with much more of an interest on particular people. It's set up in a way to make sure that the operation of the facility looks to a great extent on what a particular person needs. And that starts with care planning. There's a requirement in federal law that there be a fairly extensive assessment done of each resident relatively soon after admission. The care plan has to be done within a week after the assessment. And importantly, the care plan is developed by the resident and the resident's representative along with the professional staff. And in practice, we're not there yet. There's still too much domination by the professional staff in what you see in a lot of nursing facilities. But what happens in the better nursing facilities, and should happen in every nursing facility, is a real collaborative process where the staff comes in, the resident comes in, the resident's representative comes in, and they talk. They talk about the assessment, what the resident's capable of doing, and what the resident wants. Residents, their representatives should not feel squeamish at all about making some real requests. The nursing facility is getting paid $4,000, $5,000, $6,000, $7,000, $8,000 a month, a lot of money. And the resident has a right, legally under the reform law, that there be some accommodation made for what he or she wants. And the care planning process is where this should happen. There should be this discussion, and you should come up with a care plan that really does address the residents' needs. And facilities should understand that it's good for them too. Happy residents are better. You would rather have happier residents and happy family members, and it's something that the better facilities do and are proud of. It could be a real selling point for them. In the not so good facilities, you still see some pretty pro forma care planning, these fill in the blank type of forms. They use same healthcare jargon to just generically describe that the person is fragile or anxious or whatever it might be. But if you see that, you want to push against it and introduce the idea that the resident wants some specific things and doesn't necessarily want some jargon-ridden intervention that's already written on the form by the computer, but wants something that's specifically set up to address his or her needs. And speaking of his or her needs, the federal law is fairly good about compelling nursing facilities to make some accommodation for those. That the facility has to make accommodation, a reasonable accommodation for residents' preferences, and that applies across the board, but specifically to activities, schedules, health care. If the resident wants to get out of the facility, if the resident likes to play particular games, it can apply to food choices to a certain extent. And I and other resident advocates certainly encourage you and the people that you're working with to be aggressive about this. I'll repeat briefly the point that I made a minute ago. The facility's getting paid a lot, and they're getting paid a lot to provide high quality care. And a resident has an absolute right to say, I'd like a little attention here. You should know, this is what I want. This is the kind of attention that I want and need. This is how I want my schedule to run, and you should figure out ways of making it happen. The most obvious example of this is wake-up times and go-to-bed times. In some facilities, you'll see a very rigid schedule that says these particular people have to wake up at 6 and 6:30 and 7 and 7:30 and 8 because there's a whole assembly line. The nurses' aides are scheduled in such a way, and there's barely enough nurses' aides to cover it, and so they have to work this very industrialized schedule about waking people up. Well, it's wrong. It shouldn't be like that. You and I don't want to run their lives like that, and if at some point in the future you or I in a nursing facility, we don't want to live like that, and we don't want to pay $7,000 a month for the disadvantageous privilege of being wakened when we don't want to get up. It's wrong, and it's wrong just general ideas of how human beings like to live, and it's wrong legally here. So in all those little areas like that, we should be aware that the residents should have choices, and here's where the elder law attorney and other advocates can do a lot of education, because family members, residents will be squeamish about raising these points. They'll assume that they have to defer to the way that the facility does business routinely, but it shouldn't be like that. Because of the foundational principle we talked about, as you recall, the facility has to provide the care that's necessary to get to the resident to the highest practical level of functioning. There shouldn't ever be a need for the resident to hire private duty staff. I've certainly run into situations like that where the facility has told a family member, look, we can't provide enough care, this person requires such heavy attention that we think you should be paying out of pocket for somebody privately to monitor that person, maybe during waking hours or maybe 24 hours a day. It's wrong. The facility has to provide the care that's necessary, and it may be expensive for that particular person, but that's the nature of the business. Some people require really heavy attention, some other people require minimal attention, and it should all wash out in the operation of the nursing facility. You get a lot of these issues that are balance between the resident needs and what the facility is willing to pay for, or the amount of time that the facility is willing to put into the care. Feeding tubes should be a last resort. In the operation of a nursing facility, evidently, it is unfortunately cheaper for the nursing facility to have a tube inserted to a person and have the person fed that way, rather than have a staff person meal by meal assist the person with eating. But that's wrong. Eating is such an important thing of the thing in the way we live, and one of the pleasures you would hope in our day. And the research generally shows that once tube feeding is implemented, the person's condition tends to deteriorate, and the nursing home reform law regulations are real strong on this issue. You shouldn't have tube feeding until it's absolutely necessary. And if for some reason you or the people you represented run into a situation where tube feeding is suggested or ordered, the thing to do is to go back to the physician, investigate alternatives, go back to the care planning process and talk about the alternatives. If it's absolutely necessary, it's absolutely necessary. But there's a very high probability that in fact it's not necessary, and it's just a way for the facility to lessen the staff involvement. But if that's the case, it's inappropriate under the nursing home reform law. And the thing to do is to have a staff member or someone else assist the resident with eating as necessary. Talk about a couple of admission agreement issues right now. The facility under the nursing home reform law is prohibited from requiring financial guarantees. The resident's agreement to pay should be enough, particularly when you consider the fact that if the resident were to run out of the money, he or she would become Medicaid eligible, and Medicaid would assist in payment. But you have seen over the years a lot of situations where facilities try to get tricky with this and come up with admission agreements that have the family member, quote unquote, volunteer to be a responsible party, and responsible party is defined elsewhere as someone who, elsewhere in the agreement, as someone who's financially responsible. Those provisions should be unenforceable because the facility, they really are requiring a guarantee. They're telling the family member, look, you sign here as responsible party, that's what you need to do. The family members are being tricked because they think they're just signing up as a contact person, and instead they're making themselves financially liable, and there's no benefit provided. Go back to contracts 101. For a contract to be enforceable, there has to be some consideration on each side of the transaction, and in this case, there's no consideration on the one side. Yeah, the facility's getting some consideration. They're getting the financial obligation of the family member, but what's the family member getting? Nothing. The only possible consideration would be the admission of the resident to the nursing facility, but that's not required by federal law. And indeed, the agreement itself claims that the person is volunteering to take on financial liability. So it's important to contest these agreements. How you contest them depends on the scenario. If the resident has already been physically admitted, already in the facility, it's pretty easy to take the admission agreement and just say, well, we're not signing this, we're not signing this, we're not signing this. There's not a lot. You want to be reasonable about it, but there's not a lot the facility can do about it because the resident's already been admitted, and there's a very limited reasons for eviction, and one of them is not, doesn't have anything none of them have anything to do with financial guarantees or the lack thereof. A somewhat trickier situation is when the resident has not yet been admitted and the admission agreement is being proposed to the resident and the resident's representative. In that situation, I still think the action should be relatively similar. Don't sign it. Cross it out. Maybe go back to the facility and explain to them why you're not doing them and educate them as to why this provision is in conflict with the federal nursing home reform law. I think that's how you move things along systemically, and I personally never ever like the strategy of just signing something in hopes it doesn't come back to bite you, because it will potentially, and you don't want to run the risk of having to argue about the validity or lack thereof of these provisions in front of a court. And then finally, if the agreement unfortunately has already been signed and there's an enforcement agreement, it can be defended, and one of the grounds for defense is violation of the federal nursing home reform law. It's an invalid provision, and there's other, depending on the language of the agreement, other defenses or lack of consideration or unconscionability. If people have the wherewithal to do this, it's very helpful to bring a cross-complaint of an affirmative action against the nursing facility. I've done this in some of these defense actions. I'm defending against the complaint, but the cross-complaint says you, the nursing facility, are violating the law by using this deceptive, illegal admission agreement, and you're using it for all your people, and we request injunctive relief to prohibit you from doing that, and we request restitution to the extent appropriate, and if you're in a position to do that, it's extremely powerful. At a minimum, you probably get an offer from the facility as quick as possible to just mutually dismiss and walk away, which you may want to do. But although, as an advocate for systemic change, I also hope that some of you listening to this presentation will be interested in taking these affirmative cases and pushing them further, because this is an area where licensing agencies aren't willing to do much because these issues of consideration and unconscionability are beyond the jurisdiction of the agencies that exist to enforce the nursing home reform law itself. Also, again, talking about admission agreements, you will see a lot of arbitration agreements these days. It's helpful to read the agreements, of course, and to note that many of these arbitration agreements claim to be voluntary, and so the resident should feel perfectly free to not sign it, to cross it out, and to tell the facility, I see that it says it's voluntary, I've read it, I am voluntarily choosing not to sign it. The advice is similar to my advice on financial guarantees. It's just not a good thing for residents to agree to. The resident, if a dispute relating to the admission agreement, usually a damages case, a personal injury case, but not necessarily. Usually the resident will be better off in front of a jury than in front of an arbitrator, particularly how these arbitration provisions are described in the admission agreement. But beyond that, the stronger point to make is, or a point harder to disagree with, is that there's no need to agree to arbitration at the time of admission. The facility may make arguments about how arbitration is more expeditious and is beneficial for everybody, and the response to that should be, fine. If and when there's a dispute, let's talk about it. And at that point, we and our lawyers can make a rational decision with our eyes wide open, with full knowledge of what's going on here about what we want to do. And if arbitration seems like the most expeditious way to resolve the dispute, we can decide it at that point. But at the time of admission, when residents are coming out of hospitals, when they just had a stroke, when their life is in turmoil, this is not the time to be making decisions about alternative dispute resolution. And let's face it, in most cases, these agreements are not signed because the resident or the resident's representative is making a rational decision about alternative dispute resolution. It's just the agreement is presented to them, they're in a panic, they want to sign everything, and that's what they do. The elder law attorney might be able to address this problem a little bit ahead of time by writing powers of attorney in such a way that do not authorize the agent to have authority to enter into arbitration agreements. A lot of times litigation about arbitration in these settings ends up revolving around the capacity or lack thereof of the agent to enter into arbitration agreements. And so a intelligently drafted power of attorney document might be a real assist in matters such as these. Another point related to admission agreements. Under federal law, the admission agreement has to include all charges that can be imposed. So if a facility intends to itemize charges for certain things, and you'll see bills with hundreds of extra dollars each month for a la carte type of items, that's only appropriate if the admission agreement specifically said, we, the facility, have the authority to charge additional money specifically for A, B, C, D, and E. Otherwise, they don't have the authority. A few years back, I had a case where the family had ended up paying $12,000 extra in all these various things, and when insurance went back and supposedly covered what their nursing home bills had been, they couldn't figure out where this extra $12,000 had gone to, and it turned out that the reason they were $12,000 in the hole is because they had paid these a la carte charges above and beyond what their insurance company was prepared to pay. And we got the facility to reimburse all that money in that instance because, in fact, the admission agreement hadn't said anything about it, and they didn't have any authority for imposing these charges above and beyond what the routine per diem was. As far as advocacy is concerned, it is valuable for residents and family members to think about or to try working through a resident council or family council in a nursing facility. It's the nursing home reform law's way of encouraging democracy within a nursing facility. Not that the councils can vote and make decisions, but it's a venue for organizing and for bringing concerns to management. And as always, strength is in numbers. And for political reasons, for emotional reasons, an active resident council or an active family council can be very powerful for residents and their family members. I'd like to close by making some general advocacy points, not tied to particular federal regulations, but more to just the landscape in nursing facilities and the pressures that people feel and how the conversations oftentimes play out. Oftentimes facilities policies do not jibe with the relevant law, and the reason is that consumers aren't very knowledgeable about what the relative law is. They defer too much to the facilities, and over the years, facilities have taken advantage of that, whether consciously or unconsciously, and have implemented and followed facility policies that conflict with the federal law. And residents oftentimes are hesitant to fight back against this. I can't tell you how many times people have said something along the lines of, well, I'm really scared, I don't want to say anything, I'm afraid they're going to retaliate against me. And the message that I give and what I think advocates and elder law attorneys and others should give is that you need to hang in there. That advocacy is the right way to go. If you think that you can get better care by being quiet, you're wrong. If there's one guy in bed A and another guy in bed B, and the guy in A raises issues, politely, strongly, whatever the person's personality dictates, and asks for things, he is going to do better than the guy in bed B who just keeps his mouth shut and doesn't ask for anything, because that's the person who's more likely to be ignored. And I think all of us who work with nursing facility residents has found that that's true. People are better off if they say something. And again, they don't want to go on a rampage against the nursing facility staff, but they want to raise their issues consistent with their personality and do whatever's necessary to make things happen. And you want to be honest, that it's easier for me. I'm a lawyer. I don't sleep in a nursing facility at night, so I have to be clear with my clients. I recognize you're in a different position than I am, and I understand it's easier for me to say this than it is for you to do this, because you're living it and I'm not. But I've been doing this for a long time, and I can tell you my experience is that this is the right way to do it. And I've had plenty of residents who've had big disputes with nursing facilities, and it works out, and they win, and the facility deals with it. It's better for the resident, and it's better for other residents as well from a systemic point of view. Another advocacy tip is not to be embarrassed by actions of residents with dementia. You will get comments from facilities, oftentimes critical comments, saying that the resident has been non-compliant or uncooperative, resistant to care modalities. And in most cases, our response is, well, yeah, the person has dementia, this person has Alzheimer's. There's a reason why this resident is in a nursing facility. So first of all, there's these healthcare issues that may prevent the person from quote-unquote cooperating. And then secondly, there are residents' rights, and in some of these issues, they have the right to not do what the facility wants them to do. It depends on the situation, but these aren't prison camps, they're nursing facilities. People still retain rights to make decisions and make choices. And so we as advocates don't have to be that deferential in a lot of these situations, particularly if it's this quote-unquote non-cooperation is driven by dementia. In that cases, the obligation really goes back upon the facility to think about the assessment, to think about the care planning, and see what can be done. You hear a lot from nursing facility staff about how they're compelled to do whatever they're about to do, which is bad for your client. Well, I'm sorry, nothing we can do. Medicare law demands it. Medicaid law demands it. It took me a few months or maybe a year or so to to learn to generally disregard such statements, because oftentimes the people making them didn't know what they were talking about. They'd say that Medicare law demanded my client's eviction, when in fact that was just not true. And I think most people watching this tape are lawyers. Somebody needs to give you the citation. It's not enough, obviously, to say that Medicare law requires something. I understand when some of us are talking to nurses or to physicians or to nursing home professionals, we might think, well, this is the whole life for these people. Of course the administrator knows what's going on. I probably don't understand it. Don't necessarily think that. There's a very high probability that this person, again, consciously or not, is not telling the truth. In fact, doesn't know what he or she is talking about, and you're always better off forcing that person to put up or shut up. If they don't come up with a citation, if they can't show you what they're talking about, it shouldn't be persuasive at all that the person is waving their arms around with claims of what Medicare law requires or doesn't require. And in that same vein, you don't want to be bullied by facility policy. And that one's an easier one to understand. Of course, there's the law and there's the facility policy. Which has preeminence? Of course, the law does. And if facilities start talking about their policies and how their policies have to be followed and how their policies have been used for 10 years or throughout the chain of nursing facilities, whatever it is, their response to that is, well, that's really bad, isn't it? In fact, your policy is contrary to law, and you really need to wake up and take care of business. If you're telling me that what you're doing, what the improper thing that you're doing to my client, you're doing to everybody in this nursing facility or in all 20 of your chains across the country, and that's the way of turning their policies against them. If their policies are contrary to law, it's not a good thing. It's not a defense for them. That's a black mark in their book. And then always look for opportunities to act unilaterally. Sometimes residents are maybe particularly inclined to try to get the facility to agree to something. And sometimes the facility's not going to agree, but it doesn't necessarily matter. If the facility is asking for too much money, just pay them what they're entitled to. Or we talked about the admission agreement. If they want the responsible party provision signed and the resident's already in the facility, you say, no, we're not doing it. It's not required. The person's already in the facility, and it's up to you. But that's what we're doing. And as we've discussed, the facility's likely not going to be able to do anything about it. A couple other examples here. The psychotropic medication, if there's no consent from the resident, the family member, the medication can't be administered. And sometimes the issue comes up about videotaping in the resident's room. The facility almost always will not give permission for this, but that doesn't necessarily mean that the family shouldn't do it, as long as the videotaping is completely respectful of the privacy concerns of another resident in the room, if it happens to be a shared room. The licensing agency should be used judiciously in a lot of these disputes. I prefer handling them myself, because I know that I have then control over the dialogue. Whereas if I instead refer it to the licensing agency, let's just the state health department, for example, whatever the agency is in your state that enforces nursing facility law, I have less control over. Admittedly, they have some enforcement powers, and sometimes that's useful, but then they're going to make some decisions. And it's the more you work with your licensing agency, the more you'll have a sense of whether or not something should be referred to the agency or not. Specifically, you want to withhold referrals when there's a legal interpretation that's a little bit aggressive, because they almost certainly, unless you have some inside information, it's unlikely that the agency is going to take that step forward. And then also, if there's any issue that's arguably outside of their jurisdiction. Gave an example a couple minutes ago about the contractual issues dealing with consideration and unconscionability. That's the kind of thing that licensing doesn't have authority to deal with, because their jurisdiction over nursing homes is limited to the enforcement of the federal nursing home reform law and maybe some state law provisions as well. In all these matters, elder law attorneys are extremely well positioned to make things happen, to educate people as to their rights, to negotiate, to work with the facility, to represent the resident in administrative advocacy and litigation. And I encourage all of you to take this up to the extent that these cases are presented to you. You can be a huge help to your client, both individually to your client and a huge help in moving the entire system along to a world where nursing facilities provide the kind of individual care and accommodation of needs that they should be doing under the federal law.